Any mention?
Well, item number 4, my lord, the hearing list. I've taken consent of my learned friend, Mr. P.T. Sangma. Can
Number
this matter
4?
be Yeah, 4, my lord.
Division bench.
Yes, my lord.
Oh. Number 4, Senora.
Yes, my lord. After vacation, my lord.
Yeah, objection.
Lordship, actually, this appeal has not made it actually. On the last occasion,
You have objection or not? Yes or no?
okay, let it come after
You can
application.
say no. Why you want to make a long story? Yes, after vacations on the prayer of the appellant. Yes.
What's all Lordship?
Item number 1.
My lords.
Yes, who's for the other side?
My lords, I am appearing on behalf of petitioner, my lords.
Yes, what's the matter about?
My lords, it's a matter of levy of demand of GST on account of delay in filing of returns.
Yes.
There are two similar matters, my lord. One is of 2017-18 and another is of 18-19, my lords.
These are two periods. GST
Yes,
rollout
my
was when? July 2017.
17.
Yes, my lords.
Right. This was item number 1 is for which period?
17-18, my lords.
17-18. And number 2 is for?
18-19.
18-19. Okay. Yes. What's it for today, Dr. Mazika?
My lord, on last occasion I placed the instructions, my lord. The government has come out with a notification, my lord, addressing their grievance, my lord. So,
That is a grievance.
my lord.
With regard to,
They can now also, within 6 months from the date of notification, they can submit and rectify.
are you aware of this?
Yes,
My lords, I am aware of it, but despite the fact that the government has brought these notification in force, however,
Yes.
the respondents have still not dropped the orders. My order stands still.
My lord, if I may take your lordship to the...
Or have you filed an affidavit? We don't have the notification with us.
I placed in last occasion, my lord.
Is it here?
Do you have copies?
Yes, I do have it.
It's not here.
I'll-
Last year, the adjournment was taken by the.
My lords, we have a
Petitioner.
copy of notification.
This was the one that is.
My colleague may pass it over. The Finance Act 2024 and the notification 17 of 2024.
17?
Yes, my lords.
Where's that?
17/2024, dated 27 September 2024, my lords.
No, this notification is 8 October 24. Sir Moses, are we talking about the same notifications?
But the one I placed with your lordship, my lord.
This is
But
8 October 24.
My lord, I'll just point out here, my lord.
Yes.
Now, in exercise of so-and-so, my lord,
Yes.
I'll just read the entirety.
That's the last one, 8 October.
My lord, in exercise of the powers conferred under section so-and-so, the central government, on the recommendation of the council, hereby notifies the following special procedure for rectification of order to be followed by the class of registered persons against whom any order under section 73 or section 74 or section 107 or 108 of the said act has been issued, confirming demand for wrong availment of input tax credit on account of contravention of provisions of subsection 4 of section 16 of the said act, but where such input tax credit is now available as per the provision of subsection 5 or subsection 6 of section 16 of the said act, and where appeal against the said order has not been filed, namely, the said person shall file it electronically on the common portal within a period of 6 months from the date of issuance of this notification, an application for rectification of an order issued under section 63 or section 74 or 107 or 108 of the said act, as the case may be, confirming demand for wrong availment of input tax credit on account of contravention of provision of subsection 16. So, my lord, 6 months time window has been given to them, my lord. They can file, though adjudication order was passed, but this is what the...
What happened with adjudication order? Then the order
My lord, the moment they file it, my lord,
will be taken into
it will
consideration.
be taken into consideration. That is the whole purpose.
My lords, my lords, it is my humble request that he may drop the orders. The matter is pending before my lords. My lords may also, my lords
No,
can
we
also...
don't.
There is a
There's no
mechanism.
question of dropping the orders now until it's adjudicated whether you are really entitled to, what is this? There's input. There's
Input
double
tax
input
credit,
tax credit.
Input
right?
tax credit.
So, the moment they file, the mechanism is provided, my lord.
Yes. Yes.
My lords, it may be dropped by the adjudicating authority itself there before my lords. They have the
See,
power to do
once you
so.
make the appropriate application, then student
It will be taken into consideration. Well, there is no need for any apprehension now, in my humble submission.
So
Then, my lords,
we will keep the matter pending.
It is which will just see. It is which will just see.
This ITI is a government company also.
My lords, ITI is a government
They
company.
used to make telephones.
No, my lords. The work which we were allotted was laying of fiber optic cables, my
No,
lords.
ITI is a telephone making company, right? Before. Anyway.
It depends on-
300.
My lords, the operative part of the order,
Page.
the operative part of the order is at page 314, my lords. At the bottom of it, para 8. I confirm the demand of excess availed input tax credit for the month of November 2017.
Who's that?
Okay. Yes.
My lords,
Yes.
it is purely a matter of 16.4 and the entire matter is covered by the notification which the amendment section 16.5 which they have brought in. And if they want, we can file a rectification. We have absolutely no difficulty, but the matter
See,
may be kept
what we
pending.
just go back to what Dr. Mosca has read. It says that to the last. It says some recommendation the council hereby notified for rectification of order to be followed by the class of registered persons against whom any order section 7374 or so has been issued confirming demand for wrongdoing input tax credit on account of mentioned provisions of. Now you see of subsection 416. This has been amended now.
My lord.
Yes, my lords. Another provision, my lords, provision section 16.5 has been inserted.
16.5 has been
By
instructed, my lord.
by which demands for the concession have been given by the government for 4 years, my lords, from 2017-18 to 2020-21, and we are completely covered by it, my lords. However, the demands, the order are still standing. That's why we are before, my lords.
Yes. This matter concerning the demand for excess availed input tax credit for the months November 2017 and 18 in terms of section 73 of the, it's called the SGST, right?
CGST.
CGST and Meghalaya GST Act.
And
my
the
lords.
GST Act is before us today for hearing. Stop. Next part. However, at the outset, Dr. N. Mozika has produced a notification dated 8th October 2024, which he submits will serve to close the matter in as much as which provisions were inserted on view of the amendment
Section 16.5. my lords.
16.5 and 16.6.
in view of amendment of section 16.5 and 16 subclause 5 and 6 of the Act, rectification procedure has been provided. A special rectification has been provided. Stop. Next paragraph. This court has perused the same, and for the sake of convenience, para 1 of the said notification is reproduced here and below. Stop. Next paragraph. In view of this development, which is also concurred to by the counsels for the petitioners, the matter, it is concurred to by the petitioners. it is provided that the petitioner shall avail of a special procedure for rectification of order to be filed before the competent authority within a period of
My lords, 2 weeks.
within a period of 2 weeks. Stop. Thereafter, can we prescribe a period for disposal?
My lords may do so, my lords,
this
for
is-
early disposal.
Thereafter is expected the matter shall be processed and disposed of expeditiously by the respondent.
My lords.
Stop. However, and it's provided that till the disposal of the rectification petition, the impugned part of the order dated.
Well, no coercive action will do. Well.
Yes.
My lords, the interim stay has already been not granted, yes.
It's been granted, yes. So yes, is provided till the said application is disposed of accordance with law, no course of action shall be taken by the respondents against the petitioners. Shall we close it then? We'll close
My
it then.
lords, the only difficulty is that the orders are not available on the GST portal, so we have to file it manually. So my lords may
That's fine.
record that
Yes, it's also
they may accept
submitted.
our manual
It's
application.
also prayed that the application rectification may be accepted manually by the authorities, as there
If
might be
portal-
issues.
if-
As there might be issues with the portal. Yes, stop. With the above noted directions, these matters stand closed and disposed of. Yes.
My lords, in the next item, item 2, my lords have, because in this item has recorded that due to demand of particular month of March
Yes.
The period will be.
and November
Yes.
18. My lords, in another matter, item 2, there is a demand on account of denial of ITC due to this, my lords, and on page 352. My lord, it is of March 2019.
Okay. 350.
The only difference will be of the period,
Yes. We'll correct the order. Yes. Yes.
my lords.
Item right. Same order. We'll correct the order.
Obliged, my lords.
Item number 3.
Yes, Mr. Changrai, so
We are challenging the amendment of the District Council Act 2019, my lord.
ready?
My friend,
Mr. Paul is occupying the other courtroom.
Who's occupied where?
He's occupying the other courtroom, courtroom 3,
Who's
Mr. Paul.
Mr. Paul, he's here. Yes. Yes, yes, Mr. Paul.
Well, I'll be here for the district council, my lords. My
Where,
friend
the
here.
other respondents?
other respondents, state
State
government,
is, state is there, my lords.
only HU was here. They have filed the affidavit.
There is only state and the council.
Yes.
Yeah, what is the matter about?
But the matter relating to the amendment of the Castle District Council, succession and appointment of Chief and Deputy Chief, Maharam Samship Act, Maharam Samship Act, 2019. My lord, they passed the bill by the council. They refer to the governor.
The?
Governor has done the bill.
The
Now,
bill, okay.
Return the bill, my lord.
Yes.
Now, once he returns the bill, council has to place before the house, reconsider it and vote it, my lord. What happened, my lord, after return by the governor, district council from executive committee level to the correction and sent to the governor, and governor has given the assent without tabling the bill before the house. That is the basic grievance, my lord. Merits of the amendment, my lord, for today, my lord, I'm not praising, my lord, subject to my lord, further assertion in future. Only my submission today is a procedure, my lord. Because the lawmaking process under the 6th schedule is indeed a constitutional process under paragraph 4 of the 6th schedule. Now, I'll just point out few annexures that will be very clear. My lord, we come to page number 21. They introduced the second amendment in 2000.
You mean to say, when the bill was returned
Yes,
to the council,
yes.
they inserted amendments after that?
Yes, amendment was introduced.
Do you mean, what you're trying to say is not that the question, just bill came back and sent it back. The bill was sent back by the governor,
Yes, yes.
right?
With the
And
remarks.
then, and so the amendments were made to the bill,
Yes,
not by the house.
not by the house.
and made at the level of executive committee.
Yes, yes.
And sent back to the governor,
Governor.
who gives assent.
Yes, and governor has given assent.
Then,
My lord, we come to page number 21.
yes,
This was the second amendment they introduced, and the governor in the last paragraph, he has returned the bill
where's
for
21?
page 21 annexure 2.
Yes,
My lord, the last, my lord, in view of the above observation, the amendment bill is returned herewith for doing the needful. So thereafter, what happened? After long gap, page number 24.
this was in 2015.
Yes,
Yes,
they abandoned that one. In 2019, they introduced another amendment, page number 24, 22nd July. Now, this is the publication, my lord, publishing the bill for public opinion before placing the bill before the House of the Council. So these are some certain amendments sought to be done in section 2 and 8. Now, thereafter, my lord, what happened?
but this was written to be introduced, proposed to be introduced
Yes.
in the consultation.
Yes.
It's proposed.
Yes, proposed only. It is under the, my lord, the rule mentioned, rule 93, 76,
Yes,
73
okay.
2. That is the mandate. So
This- this is
to
amendment.
publish it, and the bill was, my lord, passed in page number 27. The next page. Now the bill was passed and published. Now basically passed by the council on 25th July 2019. It's important, my lord. Received the assent of the governor. Governor assent not yet given. And now this was published. And thereafter, my lord, the bill was sent to the governor. The party, my party came to know. So my party has filed an objection, whatever, page number 29. And thereafter, my lord, what happened? Page number 34.
No, but see, like this last line of the statement of object reasons
Yes.
at page 28.
Yes.
Certified the above amendment bill was passed by the Khasil Tamil Council on 25th July 2019.
Right. Now,
Then?
bill was passed by the council 25th July.
Right.
Now, the bill was referred to the governor for assent.
Right.
Now, when the matter reached to the governor for his assent, we filed the complaint. And my complaint is page number 29.
Okay.
And my lord, page number 34. My complaint was forwarded to the authority, council affair for consideration, examination.
Yes.
Then September, and my lord may come to page number 36. My lord.
Yes.
So the authority sought for opinion from the district council regarding the objection. And page number, my lord, 37.
Yes.
37, my lord. May I just say, my lord. The contents of the letter such, along with the enclosure as forwarded to you, white letter such, may be kindly be taken into consideration. Further, the agreement of such referred to in your letter cited above may kindly be submitted for placing the bill before the governor of such for his assent. Now, this was the communication, and page number 38, the next page. The governor office, my lord, state government sought clarification from the district council, page number 38.
Yes.
And now page number 39, same, my lord, it says, with reference to subject cited above, I am to inform you that due to typing error from the office of the Secretariat, the word land regulation appear instead of the word land administration in section such of the proposed amendment bill forwarded by the EC,
Yes.
Khasil such. Therefore, you are kindly requested to rectify the same and to take up necessary action from your end. So this was the letter written by the authority among the district council itself. Now, page number, my lord, the next page, 40, governor returned the bill. I'll come to the last, my lord, para. You are hereby requested to kindly consider amendment the above clauses and resubmit the bill thereafter.
Where
The
are
bill
you
is hereby
reading from?
returned. Page number 40. So governor has put the remarks
Okay.
and asked the council to consider it. Bill was returned. Now, once the bill is returned, they have to place before the council assembly. Now, instead of placing before the council assembly, what happened? Page number 41. notification, my lord, 1st September 23. The contempt, my lord, passed by the council on 25th July 2019. That was already done by the governor. Now, received the assent of the governor on 15th September.
So proviso at clause 2 of the bill. What's the proviso? What does it read?
My lord, reading to my lord.
Proviso, see, you just, page 14, this letter dated 25th August 2023.
Yes.
With reference letter so-and-so, the proviso clause 2 of the bill may be omitted. What's
Yes.
that proviso?
My lord, the proviso is provided, my lord, page number, if lordship kindly see page number for 38. It is stated, provided that in rights and such, the act shall apply in matter relating to village administration only and not on land regulation. Therefore, governor has pointed out this gray area.
What is omitted in this bill as passed, the proviso?
Yes.
That is omitted.
Yes.
Then-
Now they removed that one, my lord, and they submitted to the governor again, and governor has given his assent on 15th September.
No, it's not a question of adding anything, just quick omission. You mean to say that even if a clause is deleted,
My lord, it amounts to amendment.
that amounts to another amendment?
Oh, my lord.
But that's only a bill.
No, my lord, what happened, my lord?
See, it's not it's only a stage of a bill only. It has not been finally assented by the governor. For it to be brought back to the House to amend it,
Right.
you know, it's not that.
Well,
The question here is that now there was an objection by the governor saying that this proviso should be deleted with this translation. And what not deleted it, and then as it stood, it was passed in 2019, they've submitted it.
My lord.
So the bill stood correctly, whether it's not an enactment that was amended, again by only by executive committee.
My lord, my humble submission is whatever correction required to be done, either omission or addition in the bill. That requires
How do you support your submission?
my lord, if we see the 1951 regulation, the rules,
Council rules.
my lord, I have submitted the list of the books. It is very clear, my lord. My humble submission, omission
Even
or
for addition
addition.
of a bill.
Yes, omission
Or
or
omission.
addition of the bill. It requires the application of the collective wisdom of the elected members. My lord may come to rule number 92 and 93 of the Assam and Meghalaya Autonomous Districts, Constitution of District Council Rules 1951. Now, 92 may take with lordship permission.
Yes.
It says, my formal revision of bill and submission of it to the chairman for authentication. Lordship got it? 92.
Yes.
Madam. When a bill has been passed by the council, district council, the secretary shall, if necessary, renumber the clauses, revise and complete the marginal notes thereof, and make such purely formal consequential amendments therein as may be required. And a copy of the bill shall be submitted to the chairman and shall be signed by him to the governor for assent. After the bill has been signed by the chairman, the secretary shall send an authenticated copy to each of the following: to the executive committee for information, to the governor for information through the secretary, district council affairs department, government of Meghalaya, if the bill does not require the approval of the governor, being not so specified in any of the provision of the 6th schedule, or it is important mandatory, to the governor for approval thereof if it is required under any provision in the 6th schedule to the Constitution of India. Now, 93. When a bill which has been passed is submitted as per such and is returned by the governor with a message to the council for reconsideration, the point or points refer for reconsideration or the amendments recommended shall be put before the council by the chairman and shall be discussed and voted upon in the same manner as amendment to a bill, and it shall be presented again to the governor for his assent.
Yes.
So my humble submission, my lord, either deletion or omission in the bill, it requires to place before the House, and the elected body need to apply its collective wisdom, and they require to vote it out. Now,
Yes.
they did not comply this provision. After the remark received from the governor, perhaps executive committee, executive level, in exercise administrative power, to the needful correction, send to the governor, and governor has given the assent. So my humble submission is in violation of the Rule 93. So it requires to be struck down.
Yes.
Affidavit filed by the council also, they support, they don't dispute this procedure.
Who doesn't dispute it?
The district council.
They file an affidavit.
But they have filed, my lordship, kindly see the affidavit filed by the council, my lord. Affidavit dated, my lord, 28 Feb 2024. But may I take straight away to para 7.
Yes. Where's the affidavit? 1 and 2? No. This is
Para
5.
4, 5, 3, 4, 5, 6, and 7 parties. This is the council. In para 7, my lord, if I take a lordship attention
One
to para
second.
7. Yeah, they have extracted the bill itself, my lord. Page number 8 onward.
1 second.
Entire proceeding of the house.
So you mean it's rendered entire
Exactly.
act?
Lordship, correct.
So what will happen in the interim then?
My lord. So it requires, my lord, lordship interference. The lawmaking authority has abdicated its power and assumed by the executive body.
Or can
That is
we,
impermissible.
can it be confined only to that part?
Confined to my lord regarding proviso. But, my lord, my humble submission, the lawmaking process, therefore, with your permission, my submission is that addition or omission, whatever nature, consequences,
Understand?
it
You
requires
understand
the
that, yes.
deliberation of the House.
Yes.
They are exercising lawmaking,
Yes, Mr.
lawmaking
Paul.
power.
Millards, first question that would fall is, Millards, whether any procedural, Millards, not admitting, but only for the sake of argument, if any procedural impropriety would render any particular
Yes.
act, Millards, ultra virus of the Constitution. In my humble submission, Millards, that cannot be the position of law. Because here, as in para 7 at page 5, Millards, on account of what we've stated very categorically is the bill which was passed by the House, Millards, there could have been some, Millards,
Para 7?
para 7 at page 5, if my lords can have a look.
Yes.
If I may just point out, Millards, it is stated, third line from the top, Millards, it is stated that the legislative wisdom of the KGDC cannot be subservient or put to scrutiny by any forum of the executive state. The bill as passed by the House, having ultimately received the assent of the Governor on 15/9/2023, has been published in the Meghalaya Gazette on so-and-so, and these admitted facts being germane to the issues regarding the procedural validity of the passage of the bill into an act, nor fault or infirmity is visible in the entire process so as to question the validity of the Act of 2019. So ultimately, my lords, what was actually passed by the House, my lords, came to be published. There was this limited remark that was there by the Governor, my lords. It was only to that limited extent that was removed. Now, what my learned friend is arguing before your lordships is if there is violation of Rule 93, whether that would render an act, my lords, invalid. In my humble submission, my lords, that cannot be the position. Because what essentially happens is, my lords, the matter was sent to the Governor made a noting and it was sent back. As what was pointed out, my lords, that if the proceedings of the bill, my lords, they are formalized by the chairman, and my lords, they are numbered, they are paragraphed. Now, if in case it is only for the purposes of, my lords, giving it some formal shape that the chairman exercises that power. Now, once there were certain remarks made by the Governor, my lords, it came back, and it was corrected, and it was sent back. It received the assent of the Governor. Now, whether that itself will.
No, but you see one thing, Mr. Paul, that
My lords.
the suggestion given by the Governor amounted to the deletion of the entire proviso. Which,
My lords,
that's the thing. Of course, the presumption of validity of an act that Mr. Chandra has to overcome,
My lords.
like while arguing it, because presumption as validity of the act is there. So that is one big obstacle you have to climb, is the thing. Regarding the procedural aspect, then that will be examined in another way.
Because the prayer of my learned friend here is, my lords, to declare the entire act ultra virus of the
Otherwise, yes.
And ultra virus would be only, my lords, when it is juxtaposed as against a particular provision of law, which would otherwise prevail.
Repugnant to the, to the
Constitution or any fundamental.
Now you're saying that it's ultra virus because, as per the Constitution of the Council Rules 1951, the procedure prescribed that has not been followed. Correct?
Well,
Yes. So only on that that this act is ultra virus or invalid.
Infraction of any provision of the AD rules, my lords, in my humble submission, will not render a law.
That is what this court is getting
ultra
at.
virus.
Yes, this infraction of this matter, because every case is not the same. The infraction in this matter, whether it'll amount to, it'll amount to declaring the entire act ultra virus. Because to repeat again, presumption of validity of every piece of legislation is there.
but that is true, madam. Presumption is always there.
Presumption of
But
validity.
if there is an apparent violation of the rules, madam, enforced by the council under the 6th schedule,
Then we'll hear
it cannot be empty formalities.
This, my lords, had come up for consideration in certain other matters, my lords. I can place that.
Yes.
Because even in Parliament, my lords, there's the practice and procedure of Parliament. Now, infraction of any particular rule, whether that would make the law ultra virus.
Because, you see, it's not given in the
here-
schedule per se, Mr.
Here,
Chari.
my
So
contention
if
is
suppose it was like, contained in the schedule itself with regard to the manner and procedure, it's like what regarding a money bill and so on and so forth. So if that is prescribed in the schedule itself, then maybe, we have to take a different view.
two aspects, my humble submission, my lord.
What is-
The procedure aspects, my lord, and the nature of the alteration made by the council. But the procedure, my lord, the bill has to go through from A to C. It has to pass through. If there is my lord, non-adherence to that one, escaping certain forums, then be violation of the rules, procedure. But here, my lord, the effect of the changes introduced by the executive committee, which is supposed to be done by the lawmaking body. That ultimately, my humble submission, that amounts
Exactly,
to.
no, that is accepted. Your contention is accepted that maybe this infraction has been admitted by them also. But whether this infraction amount to, declaring the entire act of virus, that's the only thing we have to examine. Taking to consideration the validity of the presumption of validity. We'll hear it then, since
But-
it's a hearing today.
It is fixed for hearing.
It
in
is fixed for
fact,
hearing, my lords.
Where's RP General?
AG.
He's appearing on behalf of the state, correct? We need inputs also.
We have also filed our affidavit.
No, affidavit is not enough. You're prepared to argue the matter.
Let it come any other day. I will take up.
Otherwise, we'll consider it if they're ready.
Explanation is pretty clear in our affidavit.
What's the explanation in the affidavit?
No, that they have, that the district council has the right to amend as well.
Oh, here he is.
AG is it.
Yes.
Meet Vijay.
Where have you said that?
Subparagraph 6. Paragraph 6, 5, 6.
You understand this case, Mr.
Yes.
Vinal? Only they're saying that that this
The procedure was not followed
Was
in,
not followed. Constitutional rules was not
procedure was
followed.
not followed in passing the, now,
in
on,
resubmitting the bill.
yes, Miller. So the basis of challenge is the procedural irregularity.
Yes.
Now, so whether on the basis of procedural irregularity, law can be said to be, law is said to be vitiated, Miller, because ground of challenge of law is, into my understanding, is twofold, Miller. One, that there was no competence, and or it is hit by the constitutional provision, or it is hit by statutory provision. not on procedural irregularity. If my friend can place any case law on this point, that on the basis of procedural irregularity, which we do not admit, there is no procedural irregularity, but be as it may, my lord, even assuming that there is a procedural irregularity without admitting it, that can't be the basis for sitting aside the law.
Okay, but sir, we'll fix that. You come prepared. You bring
Well, I'm
whatever
ready.
authorities.
Yes, yes.
Yes.
It's an important issue. It's an important issue.
Of course, it's
It's a
important.
very important issue. Very vital issue.
Purely question of law, whether on the basis,
Interesting.
first there is a, whether
give you a-
my friend is required to establish whether there is a procedural irregularity. Second, if there is a procedural irregularity, whether it will vitiate the, because his ground is not that the council is not competent. His ground is not that council has
No,
not.
his ground is that the procedure prescribed has not been followed.
Yes, my lord.
And so that makes even that bill which is presented before the governor for
For
assent still gone.
assent.
Yes.
Yes, my lord. So now that is, we will, my lord, deal with this once.
Procedural part of it cannot really render a law.
That's the only question of law. That's the only question of law.
On the request of the parties, this is a matter for when? After vacation?
After vacation.
We'll have one date and finish it off.
Yes, yes. Well, good.
But you come prepared.
Yeah, well, we'll be satisfied.
Any mention?
I'm praying for an unlisted motion tomorrow. My lord.
Regarding?
Here what happened, my lord, the Sardar of Nongpo, my lord, after proper inquiry, he was reinstated in the office.
What?
After an inquiry, he was reinstated in the office. Earlier, he was suspended on some complaint.
Sardar of Nongpo?
My lord. Inquiry was conducted, my lord, and inquiry absolved him all the liabilities. And inquiry was by a judicial officer, my lord, of district council.
By a judicial officer?
My lord. Now, after he was reinstated in the month of March, again he has been suspended, my lord, on the basis of similar complaints, my lord.
Tomorrow?
Tomorrow.
Yes.
My lord, I beg to mention hearing number 29. Lordship may accommodate me. I'm appearing for respondent number 6. My lord, I pray for after vacation.
29?
29, my lord. My petition is.
I'm appearing for respondent 5.
We have serious objections, Lordship, to
Serious objection?
Lordship.
You're appearing for university?
No, but for the private respondent, my lord.
Where's the university? Who's it?
Well, I'm seeking for the first time. I never seek adjournment. Number of my friends I sought adjournment.
Where's your senior counsel?
She is before on her legs before the division.
Where's Mr. Sen?
She's there for Mr. Sen. No objection, Your Lordship.
What to do, Ms. Chandrasekhar?
My lord, just after vacation, if Lordship permits me.
Let it
It's
come,
appointment
Lordship.
process
Let it come,
only.
Lordship. Let it
Appointment.
come, Lordship. I'm praying that. Let it come, Lordship.
I have some difficulties, that is why. Otherwise, I will not.
Otherwise, you don't pay for time. All been paid from your part, you know that.
Yes.
You will have it on the first day,
yes.
reopening.
Yes. Yes.
Yes, mention this, Mr. Chandrasekhar, Senior Advocate Counsel, we have respondent number?
Number 6, madam.
Number 6. Raise that due to personal difficulty, the matter be taken up after vacation stop. The same is resisted by Mr. Chanda, who prays that there is urgency. It is further it is however further submitted by the Learned Senior Counsel. That's the first time he's seeking some accommodation.
Yes.
In consideration thereof, this is matter on reopening. Yes.
Deeply obliged.
My lord, I beg to mention item number 27.
Where's Mr. Dingdo?
He's out of station, my lord.
Let this matter come after vacation, my lord. Then.
I thought we were in the. We were just examining. I was like, yes, okay. After vacation, as the Learned Senior Counsel is not available.
Deeply obliged.
Yes. Your Senior Counsel for the petitioner. Yes. Yes.
My lord, I beg to mention an unlisted matter today due to its nature, urgent in nature. We beg to pray to take it after the board, Your Honor. The petitioners here are students who were initially granted admission into a PA Sangma Medical College, but after that they were given the admission were cancelled, Your Honor. So we beg to take the matter after the board, Your Honor.
There are similar matters already pending, I think.
Your Honor, these are different petitioners.
Slightly different matter, my lord. What has happened, my lord, that there is a state quota which was there in Khasis, Garos, and so far as the Garo quota is concerned, there were less students which were filled by management quota, my lord. Then we rescinded their admissions and said that this has to be filled by the either Khasis and from tribe. So then the students are management quota students. They are challenging that decision, my lord. It can be taken up tomorrow, my lord, because now to
be taken up tomorrow. Have you made a mention memo? Yes.
Please, my lord. My lord, I beg to mention item number 23. My lord, I pray that this matter may be come up after the vacation, my lord. No objection.
During vacation?
After the vacation, my lord.
After vacation.
No objection, Mr.
After vacation.
Grateful.
Any mention now would go after vacation.
My lord, I beg to mention item number 31, my lord, from the hearing list.
Where's Dr. Mozika? After vacation is. Yes, quick.
Your Lordship, I beg to mention item number 32.
Where's the other
Lordship,
side?
I am for respondent number 3.
Yeah, objections.
No, Lordship.
Okay, after vacations, yes.
Oblige, your Lordship. Oblige, Lordship.
Yes, Mr. Sheikh.
Chief, item number 28, Lordship, this is the Home Guards, that matter regarding that.
Yes.
Some instruction.
Come off the application. Let come off the application, Your
Lordship.
Lordship.
This is just hanging on this yes after vacations. Okay.
Matter number 26 also, Lordship, after vacation. 26.
Okay.
Yes.
But I'm trying for some accommodation, my lord. 25.
25?
My lord, Mr. Jha in the other side.
Where's Mr. Jha? Transfer matter?
No. This is that
disability pension?
invalid and disability pension.
After vacation, okay.
Some medical emergency, my lord. My mother is not well.
Yes.
But there are 3 more matters, my lord.
Which matters are those?
31, 33, and 34.
Okay, 31.
33 and 34.
31 is already adjourned.
33 and 34.
Yes.
Supplementary list, item number 1.
Lordship, this is a writ petition in regard to Order 49 of 2024, passed by the respondent.
Why there are 2 writ petitions under the same name?
The other one is regarding Wailoy, and it's with regard to...
What is regarding what? Boundary dispute?
Yes, Your Lordship.
Who's the paying for? Have you served copy on the council?
I've served copy to the KGDC.
Where are they? Yes, what's the matter about?
The petition is with regard to the order dated 4/9/2024, passed by the respondent
Where is that?
KGDC.
Annexure, page? Page?
It's at page 95, Your Lordship.
95. Yes.
Your Lordship, the petitioner herein is the...
95?
Page 95, Your Lordship.
Yes. Why you agree with this?
Your Lordship, in the boundary dispute filed in 2021, even this aim is respondent number 4, but then the case was remanded back to this aim.
You responded before?
Yes. And we already made an appeal as well. But then even the appeal was, this is the order from that appeal rising from the boundary dispute of 2021. And with regard to the boundaries, it's not in accordance with law as well, Your Lordship. With regard to
Yes.
Khasiel's autonomous...
We issue notice then. Yeah, Miss Case also stay? No.
No, Your Lordship.
But Mr. Rinklem, right?
Sinkram.
Yes, with so-and-so, issue notice. Though it's submitted that notice has been served on the office of the respondent's number. This is the council, this is the phone number 1 to 4, 1 to 3, 1, 2 and 3, no appearance been in their behalf. Petition to take steps for issuing notice on the remaining respondents. This after vacations, expected the next date. That's updates after vacations. Yes, for further orders.
Item number 2.
Similar order here also.
Obliged.
Item number 3.
His Lordship, this is the relating to appointment of a teacher who is having, my Lord, 18 months day late. My Lord, advertisement for Dadangiri appointment assistant teacher was published on 13 October 2023. The last date of submission was 30th October.
Come again?
30th November.
The advertisement was dated?
Advertisement was 30 October 2023. And the last date for submission was, my Lord, 31st November.
30th October?
Yes.
23? Advertisement.
Advertisement. In the
Now
last
the petitioner has already challenged
Yes,
the
one-
earlier round, and writ petition is pending by him only.
Yes, yes. One petition is still pending.
Then?
Now, what happened in this case, we implemented certain private respondents where I know their qualifications. But the present private respondents, I was not aware of their 18 months qualifications. So
No, but that has been settled again by the Supreme Court, correct? With regards to 18 months is fine.
No. 18 months is impermissible. Supreme Court held.
So, and
that is not permissible.
that issue is already pending before your lordship in the writ petition by the
Right.
same petitioner. The second
Right.
petition, how?
Then what can we,
No,
what are we to do now?
No, after Lordship, we filed the first petition pending. He applied for the RTI.
And some interim
And
order is also
RTI,
there.
it's true, it is true.
They can amend that writ petition
No.
only. How can they maintain second writ petition on the same cause of action?
Well, there's another, my respondent number 7, his case is additional points are there. He applied for RTI, and through RTI, he received all the information where he comes to know that private respondents has only 18 months. Therefore, he's filing. He's filing. I require for taking up together. The first case is fixed on, my lord, 30 January next year, my lord, for hearing. Lordship may take up together and issue notice.
Your lordship may not issue notice because second writ petition on the same cause of action is not. Your lordship may tag this matter with that.
We'll tag it, yes.
Tag it.
Mr. H.S. Haruso fairly submits that the issue in question is already pending consideration in WPC number?
WPC number.
358 of 2023.
358/2023. He plays an instant matter, which is going to be this matter be tagged together.
Yes.
On next date fix.
Yes.
On the date fix for 358. Yes. They are allowed this.
Lordship may issue notice.
No, we'll tag it together.
Yes.
Item 4.
We'll examine it. Yes. Since no need to notice already here, item same thing.
Same thing.
Same.
My lord, this is issue, my lord. This is 2 years they are late. What happened, my lord? Here, these private respondents, they obtained the 2 years they are late in Assam. Now, the Assam advertisement in the order says that only the resident of the Assam will be eligible to obtain two years ODL they are late. Now, these people, they obtained the 2 years they are late and apply for the post-selection process, and they got appointed.
In Meghalaya?
In Meghalaya. And my lord, the certificates I would show, there's a serious contradictions also there.
One prayer, my lord. Again, the problem is that prayer is to direct the CBI to take up the investigation, criminal case, my lord, and civil writ petition, my lord.
That is second prayer, my lord. Second prayer.
The civil writ petition. In criminal case, my lord,
if the candidates, with authority playing fraud, Lordship, can you see my prayer? Page number 18. Page number 18.
Yes.
Madam. My prayer portion. I prayed for setting aside and quashing the 2 years they are late certificates of all the private respondents, my lord.
And
set
it's
aside
not a
and quash
PIL, my lord.
Set aside and quash the selection, my lord, declaration of result and appointment of those private respondents.
And
At interim, my lord, and I'll not press for that. After they file affidavits, if Lordship permits me, I'll try to satisfy my lord to direct for inquiry.
The direction for registration of FIR, and it's a criminal matter, my lord.
But my lord, they
It's a
apparently
criminal matter. CBI and
You take this objection.
Let them take.
Mr. H.S. So if you notice, the Advocate General present with MS to only is present except notice on behalf of the respondents 1, 2, and 3.
1, 2, and 3.
Notice issued to the remaining respondents within 3 days. Just after vacation days.
Item number 5.
My lord, this is the second round of petition where in the last occasion, Lordship directed us to obtain the NOC from CM of
Well,
William.
Mr. Counsel.
My lord, and we obtained.
We can't pass effective orders now if there's no representation.
So for today, Lordship, with instruction, my lord, matter can be disposed of also. After 1 week, if Lordship matter come up.
Yes, heard Mr. H.S. Have you served to the office?
We serve COVID.
So issue notice. It is reported, it is submitted that notices have been served to the office of the respondents number. The respondents number.
Number 1 to 3. We have
7. However, there's no appearance on their behalf today. This is a matter after 1 week. Yes. For further orders.
Give the
appearance of the KHADC respondents. Yes.
Item number 6.
May please, Milords.
Milords, this is that writ petition, Milords, regarding the jurisdiction of the MSCRC to recall its own orders, Milords.
Okay.
And both the MSCRC and the MECL, Milords, they have filed their objections. And my lords
Joinder has been filed, my lord, yesterday only. I'm just...
Not yesterday, day before yesterday.
Day before yesterday, I'm just got the copy now only, my lord.
It was on Monday.
Tuesday, your lordship, may have it on Tuesday.
Well, there's one issue I just wanted to point out to my lord. My friend from the petitioner's side has filed a writ petition challenging an order in a tariff proceeding where the existing order, which was prevalent at the time when this impugn order was passed, was withdrawn or recalled. Now, this order itself does not decide the rights and obligations inter se parties between the DISCOM and the association and their members. Now, subsequently on 24th of October 24, the Commission, after carrying out the process under Section Electricity Act, has passed a comprehensive tariff order. I'm grateful to my esteemed friend from the DISCOM side. He has appended the order in part of his counter affidavit. So, my respectful and humble submission would be, subject to your lordships hearing this matter today or whichever day convenient, that the writ petition has become infructuous. If at all,
it does not become infructuous, Milords, because the question of jurisdiction remains.
Yes. Just allow me to finish, Milords. The writ petition has become infructuous because the order which now, Milords, governs the tariff for the state has been passed by the Commission. If the petitioner is so aggrieved, then they have remedies in law, Milords, to file an appeal under 111 of the Electricity Act. That's the first point. Second, Milords, the question which is now, Milords, sought to be canvassed is whether the Commission lacks jurisdiction to recall the order. Now, Milords, as I understand, inherent lack of jurisdiction is when the court or the tribunal doesn't have the jurisdiction to entertain the suit or the proceedings. Undoubtedly, the MSCRC is the only commission which can pass a tariff order in the state of Meghalaya. So, it's not a question of inherent lack of jurisdiction. If it is a question of excessive exercise of jurisdiction, then an appeal would lie, and that's law is settled. So, either which way, I don't see how the writ would still continue to be maintained after the 24th October order. That's my preliminary objection. Your lordships may hear, if they want to argue it some other day.
Since Arvind General has some difficulty, you'll have it on Tuesday. Tuesday.
10th, Milords.
Could I make one request, subject to my lord's convenience? Could your lordships consider having it on Wednesday, if it's possible? Just the 1 day's accommodation.
11th.
11th.
I have no.
11th. I'm so grateful. I'm so grateful.
Because of the parties, this matter 11th.
Obliged, Milords.
Daily list, item number 1.
Item 1 and 3, my lord, are relating to the same order, my lord, passed by your lordships. So far as item 1 is concerned, my lord, we have in item 1 and 3, appeal has been preferred by the state before the division bench, my lord. Item 1, contempt case, and 3.
My lord, the appeal preferred by the state, my lord, is not in our petition, my lord.
We have
chosen to appeal only one particular petition, my lord.
No, we have filed all the appeals now. We have filed because there were about 13 common order was.
This is that fifth pay matter, my lord.
Recommendation of applicability of work charge. That is the legal issue, my lord. That's a pure legal issue because it has got ramification for other similarly.
This is 1 and 3 is the same one.
1 and 3. Yes, and 1 in 3, my lord. There is one more issue is that. Even in 1, my lord, Mr. Langstang is chief engineer, my lord. So he is not the competent authority. Contempt could not have lied against him. He has no power. Power is with the secretary, personnel or secretary.
The pay is, my lord, it's routed through the chief engineer, my lord.
No, but if he has no
power
to do it, what can he do?
My lord, your lordships have passed a judgment.
If you go to jail also, then if you go to jail also, you can't cough up.
I'll implead, my lord. I'll implead.
And third matter, my lord, respond number 2, I am instructed to say, he has JV Lingdo has retired, my lord. So
we'll do the changes, my lord.
So he is retired, my lord. So retired.
Mr. Philemon Nongbri, counsel for the petitioner, praise allowed to implement the appropriate necessary parties. just after. Here he's allowed.
But one thing I just need to point out in item 1, my lord. My lord, during the pendency of the writ petition, my lord, there was a stay order, my lord. Thereafter, they did not comply with the stay order. We filed a contempt. After the contempt was filed, my lord, then they started paying, my lord. Now in between they again they stopped, my lord. Again they stopped. We did not prefer a contempt again, you know, considering that the matter was in hearing. Now that the judgment is out, my lord, they have to comply, my lord, because the orders are merged.
Yes, yes.
Appeal matter is
let them
pending.
file the affidavit. Then the
Malad,
orders will follow.
Malad.
You correct your petition only.
Because, my lord, there's no stay in the writ appeal. In fact, there's delay, my lord, that is yet to be condoned. And appeal has been filed only in one particular petition.
We have filed subsequent appeals have also been filed.
Deeply.
You correct it, please.
Yes. Same order in item 1 and 3, my lord.
1 and 3.
Item number 2.
This matter will come up after vacation, my lord. It's connected with the writ appeal matter.
There's no stay order.
Yes, Lord. There's no stay order, my lord, but let it come up, my lord.
As submitted that the writ appeal is pending consideration, this is matter out of vacation, so further orders.
Lordship.
Okay. But you're a ringleader, no? This Senora. Johnny?
Johnny.
He's ringleader.
No, Lordship.
Item number 4.
Agrees? Yeah.
Much blessed, Lordship.
Yes, appeal instructions. Is it all right?
I wish to see. Second page, my lord, it says, my lord, the settlement agreement between the parties appears to be in consonance with the rule position. The BSF may undertake to disperse accordingly.
Where is that?
Second page, my lord.
Subject case file is C file letter regarding legal advice.
Without the settlement agreement between the parties appears to be in consonance with the rule.
Pursuant to order dated 19/11/2024, wherein the learned DSGI Dr. N. Muzika prayed that he without obtain instructions on the settlement arrived at between the petitioner and respondent number 5, today has come up instructions, the written instructions, and has produced a letter dated 20th November 2024 issued by the headquarters BSF, Frontier Headquarters BSF, Rajasthan. As per the said communication, the settlement agreement arrived with the parties has been accepted and the department and the department BSF
agreed to disburse.
Has agreed to disburse the debt benefits to the next of kin as per the nomination.
As per the settlement.
And petty benefit, as per the settlement arrived at. Matter accordingly stands closed. The copy to communications taken on board paid part of the record. Stands closed and disposed of.
Item number 5.
Please, Lordship. Your Lordship, we have received instruction from the party. They don't want to pursue with the matter anymore. So, Your Lordship, I may be allowed to withdraw the same, Your Lordship.
Sure about that?
Yes.
MSA Khashi, Learned Counsel petitioner submits that instructions. She may be wanted to withdraw this instant writ application with no liberty.
It's okay.
So, accordingly, matter stands closed and disposed of withdrawal. Yes, accordingly, matter stands closed and disposed of withdrawal. Yes.
Item number 6.
Chief, here I am appearing for respondent number 5, Lordship. I pray for time, Lordship. I'll file.
When did you file it? When was this filed, this writ petition?
Well, this writ petition was...
You filed your affidavit, 1, 2, 3, filed.
My affidavit is ready.
You are paying for whom?
Madam, I am taking appearance on behalf of the respondent number
today itself. Okay, Mr. M.U. Ahmed has entered appearance today on behalf of the respondent number 4. As such, notice or respondent is complete up. He prays for and allowed. Your 2 weeks time for affidavit. Similar prayer made by Mr. Sheikh, which is also allowed. List accordingly and so and so.
7.
Here, Lordship, it can be disposed of, Lordship, because
yes,
this is a matter relating to gratuity and leave salary, Lordship.
My Lord, we are ready to pay, my Lord, if my Lord kindly accommodate us for paying in installment basis.
He's GGDC?
GGDC staff.
My Lord, installment, because they what I have received the instruction from the client, they have got the fund, Lordship.
My Lord, the funds are for development purpose. If he divert, then he will file before the Lok Ayukt, my Lord.
So because 4 years...
We have fund for the project works, my Lord, for development, my Lord.
4 years, 4.5 years, Lordship.
Your sanction for how much?
Sanction is
This
22 lakh 77.
77.
So how long will it take to pay it?
Maybe 6 months will pay.
6 months is too long, Lordship. Make it 3 months,
But this
Lordship.
order, the order of sanction order was passed on 8 August 2023. Yes, my Lord. And we are trying. It's not that we are saying, no, you are not entitled for.
Yes, Mr. S.A. Sheikh submits that as the respondents are ready to release the sanctioned amount of gratuity of the petitioner, perhaps the matter can be closed up. So Mr. S.D., however, on behalf of the respondents, though agreeing to the proposal, prays that the respondent be allowed to complete the same in 2 installments.
3 installments, my Lord, will
3 installments.
3 installments, 6 months will pay. Every 2 months will pay.
My Lord, I have a prayer for interest, Lordship. My similar matter, my Lord have already same issue. They have same stand they have taken, Lordship.
They have not paid within 3 months.
That one already paid, Lordship. They had already
Let them
complied.
take 6 months because you'll get how much? 7 lakh something per 2 months. Yes.
Make it 4 months, Lordship. I will get the interest, my Lord. Lordship is correct, Lordship. But the thing is that, Lordship, he is suffering from
Again,
some
my Lord,
sickness,
if-
Lordship.
if we are
See,
not in a
if it is
position to
4
pay,
months
my Lord.
at least.
See, if he's not present to pay, the financial
true.
condition is such, that means it's difficult for them to.
Yes, true,
even-
Lordship.
So,
And he is not the only one.
It is not a case that they cannot pay, Lordship. They can pay, Lordship, because they are paying. Once they come to the court, then only they are paying, Lordship.
We are
It is not
arranging
that.
from here and there, my Lord. We are arranging.
Make it 4 months, Lordship.
6 months, my Lord, by prayer. My Lord.
okay,
6 months, my Lord. My
make it 6 months, 3 months or something, within 6 months, yes.
Try. Similar.
Though agreeing to the proposal. To be paid within 6 months. Though serious objections have been raised by Mr. S.A. Sheikh, considering the matter and the financial situation of the respondents, the prayer of Mr. D is allowed. Stop. It's made clear that the outstanding payments should be made within a period of 6 months, positively. Yes.
And 3 equal installments.
My Lord, I have prayer for interest, Lordship. That is, my Lord have already.
The component of interest will be considered also by the respondents.
My Lord, the difficulty is that in the similar measure, my Lord have already issued that 6% at the rate of so-and-so, Lordship. Now they have given in other matter, Lordship, only 1 year interest, Lordship. So what I am praying, Lordship, my Lord have already passed a similar judgment in the other cases, Lordship. If my Lord...
Let's see.
They are saying that there is no direction that we have to pay from the date of entitlement and all. That is why they have calculated for 1 year and... My Lord will pay para 5 and 6, Lordship. 4, they have taken the stand that we don't have the fund, Lordship.
Then your amount get delayed further. Yes, but then interest. No, last line. Yes, the quantum, but then it will be at 6% only.
Yeah.
Yes, the sum. The component interest at 6% interest will also be allowed on the amount of gratuity from the amount it was due from 23.
No, this is from the date of retirement, Lordship, the
When was that?
30th June 2020, Lordship.
That cannot be, my lord. It has to be from the date of sanction, my lord.
No.
Unless we clear the papers and all, my lord, sanction order is not issued.
My lord,
sanction order.
division bench order, my lord, was a part of the bench, my lord. My lord, relying on that division bench order, my lord has directed, Lordship.
And
they have complied, Lordship. They have complied, Lordship.
The case was different.
No, same case, Lordship. They have complied, Lordship.
Where's the division bench order?
Division bench order, Lordship, I have not enclosed, Lordship, because my lord have relied.
Lord has forgotten everything.
So that is why. That is from the date of entitlement till the date of.
See, we'll see it from the date a amount of gratuity became due. There is a payment of the same.
Yes. Master.
Item number 8.
Master.
Yes.
My lord, on the last occasion, we have already apprised this court that this particular case, my lord, there are 3 complaint letters enclosed. However, the petitioner is a part of the parent's guardian. So, my lord, on the last occasion, one of the occasions, we have already informed the other 2 complaint by the NGO has already been withdrawn. And so far as the parents, we are waiting. So, my lord, we have instruction that they have already withdrawn their complaint, my lord. I would like to place this copy of the withdrawal letter, my lord.
May I please, Your Lordship, I am entering appearance for 6 and 7, my lord. Respondent number 6 and 7. Some time to file.
It's withdrawn the application already.
Some
My
new
lord,
development has
Secretary of the school. I'm still awaiting proper instructions.
So, my lord, if the application, the complaint under which they have based the writ petition has been withdrawn, my lord, there is no question of...
Let them bring by way of affidavit, my
As per
lord.
my instruction, my lord, the Director of the School Education has issued a letter to the Deputy Commissioner West Garovins to conduct an inquiry, my lord.
My lord, that is secondary. If I may clarify this, my lord.
Let us bring
Because,
to the notice of this,
because, my lord, if the letter has been withdrawn, the inquiry does not, is required. So, my lord, now what happened, it was during the time the complaint has not come forward, we have called for the inquiry because that is based on the complaint. Because in the complaint, they have made a prayer that to constitute an inquiry committee to look into the entire issue, my lord. So now, my lord, director has also issued, requested the Deputy Commissioner of...
Where's Mr. Paul?
So, my lord, that is the issue. But then, my lord, in the presence of the complaint letter,
He's on next
that also may not be
So
required.
you have no idea about the case.
Let them bring by way of affidavit, Your Lordship.
I have a letter of the Deputy Commissioner being directed to hold the inquiry also, my lord. But, my lord, the basis will be the withdrawal of the letter on which the entire inquiry has to be constituted.
Anyway, we take it up.
After vacation, I file my application.
Yes, a note be submitted by Ms. Al Kohli, letter counsel for the state respondents that the cause of action no longer survives in view of the fact that the complaint on which the petition is based has since been withdrawn. Mr. S.K. Hassan was entered province today itself. Praise
It will be 15
on
July
behalf of
2024.
Yes, my 6 and 7.
on behalf of 6 and 7, Mr. M.U. Ahmed, and from 5, please allow some time to file their affidavit stuff. Accordingly, let's go out of the vacation. Yeah.
Hello.
Item number 9.
Yes, Mr. Nahar.
As per the instruction order of this letter, we have filed the affidavit, my lord.
What affidavit? Rejoinder?
Not rejoinder, my lord. Additional.
What order was 1911 was?
They were to file an affidavit indicating that they have not applied for the post under the...
The reasons are to be brought into record, my lord.
Yes. So what's it for today?
Oh, this is for filing this.
You filed it?
I filed it, my lord.
They have filed, however, this is connected, connected with item 17 to 20.
Right, the same matter, as in 20 years.
No,
We have not received their affidavit issue. In item 17 to 20.
No, it's, I am appearing for item number 9 to 15, and other similar cases appearing.
Come forward. Yes.
Appear on behalf of the petitioner in item number 17 to 21.
17 to which don't PC number is it?
3802.
This is 330336.
Yes,
You are
madam.
appearing.
Yes, I
You
am.
filed an affidavit indicating the fact that none of the applicants have submitted the applications for the selection process, correct?
Yes, my lord. Reasons.
Yes. By the way,
However, Your Lordship, we've not been able to file our affidavit. I require some more time.
why? They have applied for the post.
No, Your Lordship, but we'll bring it on in record.
You have been 381, 384. Has the advertisement stayed?
No, my lord. Not here, my lord.
Selection process over.
No, not yet.
We received instructions that on the 7th, the examinations for the post of handyman will be held on the 7th of December.
Those,
And for the rest of the post, it is tentatively posted for January.
petitioners are not, none of those petitioners are in that post of handyman. They are for the other post. Those posts, they have not been, no examination has been for those posts.
So far, we have information that the posts which were holding by the petitioners has not been taken yet. Any process?
Hasn't been advertised.
No, advertisement is there, but examination has not been there. But for the higher posts like grade 2, 3 are being taken.
See, you can't have a claim with the post, but are you age barred now?
Yes, age barred, my lord.
You file, when can you file your affidavit?
We've not
By
filed
2
Your
days. You won't file.
We will be filing, Your Lordship. We will be filing.
When? We'll take it before vacations on 16th. Yes, MS, huh? Yes.
We'll file.
First record Mr. Nath's cases. That is 3302, 336. In this series of petition, Mr. H.R. Nath submits an affidavit has been filed indicating the fact that the petitioners have not put in the applications pursuant to advertisement dated 1st August 2024. Yes, MS Tunga, what do you have to say?
That we were to file affidavit, so let the matter be taken up after the.
Yes, MS Tunga submits as the affidavit has been received. We require some instructions. Stop the matter on 16th December for the orders. In the other set of matters, it is submitted that the affidavit as directive order 19/11/2020 to be filed. This pray and how much time do you pray? You can file in 1 week.
We'll file it in 1 week, Your Lordship.
Now it's the 5th. Yes. Petition permitted to file affidavit in 1 week. List the matter together. A list on 16th December. Yes, for the orders. You file it, then you know.
Madam, 9 to 15 item number. Item number 9 to 15, similar.
16.
Your Lordship, I've been instructed since the grievance of the petitioner is that they have not been heard before passing of the order and issuance of the patter. Could this matter be referred back to the office of the same of Million and let them hear and pass the accessory order accordingly?
It can be disposed of. The impugned orders at page 123, that can be set aside. 123 and extra 19. This is the order passed by the same of Milim deciding the issue.
123.
This can be set aside and the matter can be remanded back.
123. 1 second. You're not heard at all.
No, my lord.
11 matters.
In fact, the complainant himself passed away, my lord, in between.
The complainant himself.
He died, my lord.
And
He
who are
passed
you
away.
then? He's a predecessor in interest.
No, my lord. He was our uncle, so there was a joint patta, my lord, ancestral property.
Yes.
So the deceased person wanted the patta to be only in his name, my lord.
Yes. Take down. What's the arbitration award?
Well, it's a private arbitration, my lord, and the civil court has in Guwahati has already held that that is not binding.
Okay, the incident petition has been filed. Is the incident petition directed against the impugned order declaring the patta number 233?
Yes.
As of 2022 issued by the respondent numbers, email number 1.
Yes. 1.
As null and void. Stop. It is submitted by Mr. Firman Dongbri, the counsel petitioner, that at the time the new patta, the new impugned patta number 113 of 2024 was issued with respect to the property in question. The petitioners who belong to same joint family, yes, were not heard. Next paragraph, Mr. Sundram, on behalf of the respondent number 1, has submitted their instructions, and as the petitioners were held, the respondent number 1 is agreeable to allow them to file their written statements,
yes,
or objections, and the matter be heard afresh.
Yes,
yes. Considering the submissions made by the counsel for respondent number 1, this matter is disposed of at this stage itself by setting aside the order dated 11/3/2024 issued by the CMO Milliam, respondent number 1.
And the patta.
And that,
And the patta
and the
also.
consequent patta, and the matter be directed to be heard afresh by the respondent number 1 in accordance with law. Stop. When will you go to appear before?
Anytime, my lord.
Yes, when
can issue
when can
notice,
you go
my
to
lord.
appear?
I can seek instruction
Yes,
and then take steps.
Mr. Sundram submits that the respondent 1 will accordingly issue notice to the petitioners and the sole respondent for fixation of dates to take up the matter. Stop.
Deeply.
On those as ordered above, matters accordingly stands disposed of. Yes.
Deeply.
21.
Yes, what's the matter about?
Lordship is appointment on compassionate ground, Your Lordship.
Yes. Where's the instructions?
Your Lordship, when the father died, the father of the petitioner died, he died
In the year 2008.
Your Lordship, which they had applied, Your Lordship, but at that point of time, the mother was still in service. She was a government service. Which is that fact, Your Lordship.
Let me file affidavit. Ms. Alangwa submits that instructions be received. She received this stuff. She postpones allowed 2 weeks time for affidavit. This thereafter and so on. So yes. What's your name?
B. Marbanyang.
Record and be present behalf of the petitioner. Yes.
22.
May it please your Lordships.
May it please Your Lordship. Your Lordship, I'm entering appearance on behalf of respondent number 3, 4, and 5.
Yes.
May we allow to file affidavit, Your Lordship?
MS Ekharshi is a little bit today.
We are just a formal party,
On
1 and
behalf
2.
of 1, 3, 4, and 5, and as such, notice complete all respondents. She responds allowed how much time?
How much time?
2 weeks time to file affidavit. Just thereafter.
Lordship, interim may be extended, Lordship. The interim protection, Lordship.
Interim order of initial
Lordship.
shall be extended till the next date, yes. It's extended till the next date, yes.
Hearing, supplementary list 7.
Yes, Mr.
But I've taken instruction. In fact, I've also called the candidate here in court, my lord. Our first concern is, my lord, regarding the validity of the NEET score, my lord, because it's normally valid only for 1 academic year. So there will require
Where's the state? You get another seat during the current academic year. See, the thing is that what has happened here is that, as this court has observed yesterday, it's not the fault of the petitioner nor fault of the respondent. And if the records have been studied by the court also, there's no foul play, there's no manipulation. Only thing is that applications were received earlier, the seat was released earlier, then the respondent who has a higher NEET score came later. That's reflected from the records. And even the government was trying to fix it that it was a mistake and there's no policy in place with regard to allotment of seats. And so it's come as a first come, first serve basis. But then merit has to be given due recognition. So, and then that is why, in consideration of merit, they tried to change it, but then they've already invested the right, they've already joined.
We do understand that, my lord.
No, but the thing is that that is what what the common instruction, whether there's no other seat.
He's willing, my lord. The state will have to answer that. Whether
Whether any seats are available or not, I have no instruction, so I cannot make
Well, even then, but it depends, it'll be difficult for the student because he has to cope up then if the session started since October. Since?
Yes, Lordship. 1st August.
1st August.
1st August. So as there is that decision of the Honorable Supreme Court, Lordships kindly have it. It's in my list 2020, volume 17.
I was just, our second concern is, my lord, regarding the frequency of these seats being available to the state, my lord. Whether it's
No, they will make
yearly
a special.
basis.
They will make a special, special endeavor.
Yes,
because it's their mistake.
Their mistake.
They don't have a policy. Then they have to have a policy before they issue any list. They should, they should have a cut-off date for any persons interested who search a BDS to apply for an MDS seat. Then after the cut-off date goes, then those persons who are in consideration will be given. What has happened now? 4 or 5 people have applied. Now, as per the merit, now this petitioner is 5, I think 6 people. Then other 2 applicants came subsequently after the seat has been released. So what can you do?
My lord, the proposal is acceptable to us, my lord. What has come from your lordship?
No, that's why we wanted instructions. Whether
he's willing, my lord. He's willing.
Any seats available in this academic session.
This academic session, my lord.
instructions on that.
Yes.
So in this judgment, 2020-17 SCC 465, please have page 479.
1 second.
Yeah, page 479, my lord. Para 13. That the next year you can increase the seat. It doesn't mention the need is required anymore. So my friend's concern was whether he'll have to go with the NEET score of this year or not.
Yes.
Please see para 13.3.
Yes.
So this reads, in case the court is of the opinion that no relief of admission can be granted to such a candidate in the very academic year, and whenever it finds that the action of the authorities has been arbitrary and in breach of the rules and regulations or the prospectus affecting the rights of the students, and that a candidate is found to be meritorious and such candidate student has approached the court at the earliest and without any delay, the court can mold the relief and direct the admission to be granted to such a candidate in the next academic year by issuing appropriate directions, by directing to increase in the number of seats as may be considered appropriate in the case, and in case of such an eventuality, and if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case, the court may direct to reduce the number of seats in the management quota of that year.
It will be a special case.
Yes.
Just a balance equity.
Yeah, agreeable, my lord.
Just school wants to know whether he can accommodate this academic year, so he won't lose 1 year.
Yes, my lord. So
otherwise,
state
orders will follow.
My lord, state will have to.
So I think Lordship had made a mention yesterday that from the records it appears that the state did make an inquiry with the college.
Inquiry, but then whether there's there's any other seat available.
Other colleges, man.
Yes, so I think what
from 2 colleges, the King George and this Regional Dental College, and they've said that they don't have the.
They don't have
they cannot, because as MCI regulation, they can't increase number of seats in their respective institutions.
Lordship.
Unilaterally like that. That's a process.
Lordship.
That is why.
Then my lord, the state will have to come up.
You just come sanctions on Monday if a seat, otherwise then we'll pass orders if they be accommodated next year.
Yes, sir. So in terms of this, I don't think NEET will be an issue anymore.
It's not. In fact, it's a very strange case, but it's not really anybody's fault, because when I'd gone through the records also, there were a lot of endeavors to to correct it. And once a person's been with civil consequences, they have already undergone 2 months.
Because my lord, had the petitioner been, my lord, her allotment was not cancelled, I would have come to court, my lord, on the basis of merit.
Correct.
So my lord, again, we are agreeable, my lord.
So I don't think the NEET will be an issue anymore in view of this direction.
It will be an issue. It will be a special consideration. So the state quota, whatever they have for next year, they'll have to accommodate.
Yes, my lord.
And third, my lord, refund of fee, because even I have taken admission and paid my fee, my lord. So that will also.
But have you made? But then you'll have to file a separate proceeding against the college.
No, college I'm sure will refund it. I don't think there should be a problem.
Directions, but they're not a party here.
It's not a party.
Not a party, but they'll comply with that direction. I'm sure, my lord.
Yes, Mr. Freeman, Nongbri has obtained instructions from the respondent number 5 and submits that the response agreeable to accept a seat for the next academic year. However, this court has put a query as to whether independent academic year additional seat would be available to accommodate this respondent in view of the peculiar facts, circumstances of the case. Stop MS 8 हुआ, this please he made out to obtain further instructions. We list it on Tuesday then? Or Wednesday? Wednesday for the orders, yes.
Tuesday is fine, Lord. They should have it.
We Wednesday, 11th.
Lordship.
Deeply
obliged, Lord.
Daily list 24.
Your Lordship, I move an application for allowing to collect the mushroom. For the last 7-8 months, no trucks has paid any mushroom to us. That's GM Apsara.
Is the trade continuing now also?
Till now. So trucks
Is
are
the trade
going freely
continuing?
and the roads become dilapidated condition. So CM needs to repair the roads. So that being a reason, because last almost from May, no trucks has paid anything.
Where's the state? On the side. Yes.
Your Lordship, I had made a submission on the last occasion when this matter was moved also, Your Lordship, that this instant application is not maintainable, Your Lordship, as there is already a missed case that's pending with regard to collection of tolls, wherein we had already filed our objections also, Your Lordship. If Your Lordship has the order dated 9/9/24 passed in missed case number 164, Your Lordship.
9/9?
9/9/24.
Yes.
Your Lordship, missed case number 96 is pending, Your Lordship, which is with regard to the collection of tolls.
Where's your objection, MSD Cruz?
Lordship, we filed it, Lordship.
When was it filed?
We have filed our objection to the miss case number 96.
Not 96 is 114.
1164.
164 rather, sorry.
164. No, they have not filed.
Lordships, Lordships, I had submitted before this court that the subject matter, Lordship, the subject matter is covered by miss case 96 and 85. 164, the miscellaneous application.
There's nothing recorded here.
No, Your Lordship, let me clear it. what happened earlier, the council who was conducting wanted, when the collection DC has ordered to stop the collection, thereafter wrote a letter to Deputy Commissioner to allow. So, but thereafter here they approached by the 96 this case to allow to continue the earlier order of your lordship. But that was not done. And my contention is different, not to allow to earlier to continue, that the order given 144 order issued by the Deputy Commissioner, I am against that. Due to that, your lordship, so everything has been stopped. I am against that order. It's not the 96. 96 allowed to earlier stay order to continue. But that has gone, so many things has happened, your lordship knows. So thereafter, Deputy Commissioner issued an order, and that is in my missed case 164, if your lordship is pleased to come.
Yes, sir.
That is a challenge in 164, your lordship.
This 164 is the
This is
miscase
for
by the...
order dated 14/2/2022.
No,
That is the
who's
order.
applicant here?
Oh, 144 order is your...
The one miscase 164?
164 order dated...
It's by the Majai Export Association?
Yes, sir.
You are the Majai Export Association?
No,
my
I'm
lords,
for
it
the...
is-
here,
It
here-
is filed by the CM, my lords, in his individual capacity as Freeman Singh CM. At page 2, my lords, your lordship will find it.
So
Okay,
I'm
okay.
against the order dated 10/5/24, whereby 144 has been imposed.
One second. Let us...
There's a miscase earlier filed.
That is a page
This was
6A
filed
of my
subsequently.
miscase, your lordship.
This is the ones filed earlier.
By the district magistrate, stop prohibiting me from collection.
This is pending.
And I
Show
say,
the causes.
one, your lordship.
What to do, Mr. Mahanta? If the money is collected, repaired the road, it's gone to the pockets of the...
No,
it's gone to the HEMA, gone to the pockets of the council.
That your lordship.
I mean, that is something which...
That is
court now will be very reluctant to allow you to,
No,
to collect any
your
money.
lordship, that wasn't happen. I'm not aware of.
And the thing is that we have, we are in a mind to give directions to the state to
As a matter
maintain
of fact,
the
my
road
lords,
and to, keep in good repair.
No, your
As a matter of
lordship,
fact, my
this
lords,
is CM's road.
if I may just interject, my lords, it had fallen from this honorable court, my lords. The state was to seek instructions as to whether they were willing to manage the road or not, my lords. That instruction has not been placed before your lordships.
No, we went, yes, because he said it's not a
There was
PPP road.
there was a specific query to this effect, my lords.
Dr. Mozika has left the court.
So-
Advocate General has left, Dr. Mozika has left, everyone's left, yes.
My lords, if I may.
Yes, let Mr. Mahanta complete.
My lords.
Yes, what
So,
we want to show from here?
That is at 6A page.
At page?
The order of the district magistrate, your lordship.
Page?
Page 6A.
6A?
A capital A, Annexure 1, your lordship. This is order under section 144 CRPC, dated 10th May. Lordship has got it. Lordship got. From the middle, your lordship. Therefore, the considered view of the also to prevent law and order situation, they understand hereby strongly prohibit the operation of the unauthorized collection of tool in check gate, tool gate, and any form of formidable collection along the national highway, state highways, and major or district roads of East Khas Hills. Now, therefore, in excess of the confined under section 144, so and so IS officer, district magistrate, Ceylon do hereby pass this order under section prohibiting collection of tolls within the entire district of East Khas Hills district. So I am against that order.
Entire district?
Entire district.
Then?
So,
It's
entire
not-
district means
it does not-
ours also included
it
because
does
this
not-
is
it's not
pertaining to
referring
this
to
order
your-
they have given, but the order came like that.
So, whereas the exporters have agreed to voluntarily halt the plying of trucks.
Yes, yes.
See the order?
Yes.
Whereas, shall I read from the top? Whereas been brought the notice of the undersigned, the plying of limestone export trucks from Unti to 0 point, part of the route leading to Majai was stopped by the inhabitants of Majai.
Yes.
Yes.
Yes. That's
Whereas exporters agreed to voluntarily halt the plying of trucks till amicable solutions arrived at between the two parties, the Prohibition of Majai and CM Sora, has it been arrived at? As per the what's
No,
written here in
that
the
was
order?
done by the district council. District council.
No. See the second paragraph, Mr. Manta. See, we're just going on records. I'm not going, court not going anything else.
Yes.
Just second paragraph. Whereas the exporters
whereas there is illegal collection of toll by the Siam of Sora from export truck that passes through the
No,
Majai.
read the second paragraph first.
Whereas the exporters have agreed to voluntarily halt the plying of trucks till an amicable solution is arrived at between the two parties. There is Darbar Strong, Majai and Siam of Sora. So, of course, amicable that has not been done due to this order. In fact,
No. This order is consequent on that. You see, the thing is that whereas the illegal collection was Siam Sora from a truck that passed through Majai Line Custom at rupees 400, okay, that's fine.
That 400,
that's fine. So, but second paragraph, have we had a meeting with this, because this arose and caused the order because 184 proceedings were drawn out because of the obstruction caused by the people of Majai to the trucks, correct?
No.
This was recorded in
The
order.
400, I agree, Your Lordship.
Then?
Due to the 400 collection, entry point and exit point, that is the...
No. See, you're asking for to allow the CM Sora to correct the tolls. Now, until the court's clear about this position, we're not inclined to pass any orders right now, as because it's a conditional kind of order, 144. But trucks are plying now. Are they plying now?
Whole day night they are plying, Your Lordship.
They've reached amicable solution.
Whole day night they are plying,
Then?
yes. Whole day night they are plying.
That's because, my lords, there's a stoppage and collection of toll by the applicant before your lordships.
Whole day night
Now
they are
whatever
plying, the road is in a dilapidated
Well,
condition.
That's the point. You had the opportunity. You've goofed up, so you can't put the onus on the court that that the road or on the exporters the road is destroyed.
That part I agree.
That you collected crores, and if you can't administer your own ilaka, then it's better if it's given to a third party then or the government. Then they'll look after the
Your
road.
Lordship, man, give us a chance, Your Lordship, please.
Then
Your
you
Lordship,
let the government look after the road.
Because Your Lordship, I have stepped in now.
That's why we had floated idea last time that if it's creating so much problems, then and the way the revenue is handled, I mean, CM Sora doesn't need this revenue also.
The Lordship has given us that proposal, Your Lordship. We would like, the state is ready to
Take over the road, Malad. That's what it had fallen from this honorable court, Malad. So otherwise also, Malad, there is one.
See, Mr. Manta, whatever it is, other orders are going to follow in this case also with regard to how the orders of this court have been twisted and misinterpreted to whoever's advantage. That is a different aspect. But the thing is that right now, with regard to this order of 144, until this is the court is it's passed orders earlier on since 22 allowing you to collect, and it's been misused. The road was never repaired. The money went off somewhere else. As the CM Sora made statements on oath before the magistrate also.
Yes.
With regard to where the money is disbursed.
That has been given.
So can the court still repose trust in such an authority that we give you opportunity again to correct the tolls that the same thing will not happen?
No, it won't happen. That undertaking
How can you
be
say
given.
that?
No, Your Lordship, that undertaking, I am here, Your Lordship, that undertaking I'll assure that they will give you, Your Lordship.
You file an affidavit. Or you file an affidavit whether you're ready to take off the road.
also, if Lordship for the moment,
Take out that affidavit of the state.
Because Your Lordship one decision that Masur is the only collection that CM has.
Yeah, of course, but then if they're not using it to a proper purpose,
No, that will not be mutual.
and if the trade's being affected,
I
if
understand.
trade's being affected, that means the court has to balance equities, Mr. Manta.
Yes, that I admit.
if Lordship is pleased to kindly have a look at Ms. K.S. 164 at paragraph 13, that is the first interim order, page 13, Your Lordship. That is the interim order passed by Your Lordship. Page 13, Your Lordship.
Para 9.3.
Page 13.
Page 13, Your Lordship, that is the first interim order, Your Lordship, part Your Lordship.
Yes.
Paragraph 9. I'm taking Your Lordship to page 14. Lordship, kindly have a look at clause 6.
4.
No, I'm.
Just 6.
I'm taking Lordship to 6. The Himas Ora submitted a record on the amount received in the collection account. Whether this has been done or not, Your Lordship.
It is done.
The report of the magisterial inquiry report, Your Lordship, speak otherwise.
No, that is correct. That is why this court is not inclined.
No, Your Lordship, if Your Lordship, to that effect, if Your Lordship allow me to submit.
But even the division bench took note of the fact that the customary right, the rules maintained by them, that they corrected. But then it seems that they took it as a bounty or something that they have to exploit.
And there is another miscase, Your Lordship, that is in miscase number 96, Your Lordship. And in that, Your Lordship, a misleading statement has been made.
Again.
In paragraph 6, in paragraph 6 of that misleading petition, Your Lordship. If Lordship, kindly have a look at miscase 96, Your Lordship. Lordship, kindly take up miscase 96 of 24, Your Lordship. And Lordship, kindly see paragraph 6 at page 6, Your Lordship.
96.
Lordship, yes.
Miscase 96.
Miscase 96, Your
No,
Lordship.
sure.
This the reply, the affidavit reply filed by the CM of Sora in this case number 96 of 24, Your Lordship. The reply, Your Lordship.
The reply.
That reply has been filed by them with regard to the objection filed by the state when the order under 144 has been issued by the Deputy Commissioner of Law and Order. Lordship, let me assist you.
One second.
Let me assist Your Lordship.
This is right. It's become like a paper chase.
Let me assist
you.
This
Paragraph
is,
6.
Lordship, that is
Yes, got it, yes. Paragraph?
If Lordship, can you come to paragraph 6 at page 6, Your Lordship. Somewhere in the middle, Your Lordship. However, Lordship, can you see? However, Lordship is with me.
However, the applicant collected.
Yes, the applicant collected to amount as usual entry and 200 exceed entry and exceed is read and understood by the, as the same was suggested and advised by the office of the sub-divisional officers. Lordship, see, Lordship, the blame has been given. The blame has been put to the sub-divisional officer, Lordship. Then, Lordship, kindly come to page 48.
Of this affidavit, of this reply.
Lordship, Lordship, kindly come to page 48. That is the meeting, Your Lordship, on 21st September 2020, Your Lordship, in the office of the sub-divisional officer, Sara, Your Lordship. Where is the kind of that suggestion, Your Lordship, given by the SDO?
No, forget about that. Even the order of this court, you see at clause
It's
3.
very specific. Clause 4.
Clause 3, clause 4, 200 rupees only, and it's this direction issued.
Those are all wrong.
Clause 4 says, my lords, there should not be any overcollection.
No, records are maintained.
Because that is why, Mr. Manta.
No, Your Lordship, when records are maintained, but here, what is happening, of course, I am not going into those. Your Lordship will see the CM.
There's been total misuse of the orders of this court.
Lordship, I pray, Your Lordship, may expand this writ petition, Your Lordship, by including all the traditional head, Your Lordship.
No. Why should you expand it?
That will go beyond. It's much beyond.
It's not that.
After all, it's a public money, Your Lordship. It's collected.
It's a public money. It's a question of, it's trade and commerce. Now the concern of the court that should be the court respects the rights of the customary traditional heads also. If the rules maintained by them in their own roads, that they run the business in a proper manner, correct your tolls and so forth. But if the court had given an order allowing them 22, and it was totally
misuse.
I mean, not misuse. I mean, the orders of the court, they won't contempt the orders of the court the way they're collecting. So that is why.
I'm not against customary collection, Your Lordship.
So
What
that
I
is that
would
happens.
like
So
to
whatever.
submit, Your Lordship,
No,
is-
Your Lordship, may I just submit, Your Lordship? Though I have entered in Your Lordship, what is happening? If Your Lordship allowed to collect it, to maintain the roads, Your Lordship, this is the only motion that the CM has, and nothing else.
They'll come with affidavit that the state maintain the road. That it
Yes.
doesn't need to be with the same Sora anymore.
Exactly.
There'll be a public road.
But CM wants to maintain it, Your Lordship, because that is falls within the CM's, Your Lordship. That is the reason.
22 to 24, Mr. Manta, he had opportunity.
I know. That has been misused
Otherwise,
by
also,
somebody
if
else,
the
Your
main
Lordship.
issue is decided
No, Your Lordship,
in favor of the
CM
petitioners,
did not
then
misuse it. It was
this
a-
argument of the CM will not
Of
hold.
course, I cannot castigate upon others. Your Lordship will see the reports of the SDO, whatever given. So, the ill advice given, Your Lordship, that is the honest confession that Mr. CM made before the
Then
inquiry.
you seek recovery from whoever gave ill advice to augment the revenue of the CM that's been lost. Have you filed a criminal case?
No, criminal
Then?
case I didn't file.
Have you taken any steps?
No.
Have you made a complaint to the Bar Council?
Nothing.
No, nothing
Then?
has been done.
Then what are you saying your rights have been wronged? You haven't taken any steps to protect your own interest. If that has been wrong advice given to you, loss of revenue, make a complaint.
I know.
Then to wait for the court to pass orders to drawing up complaints.
So at least Your Lordship, for the in the meantime, if Your Lordship is kind enough to look into the...
We will dispose of the entire matter, and is he ready today?
I can-
The application, Your Lordship will put that affidavit, Your Lordship.
Let that affidavit come on record.
As proposed by this Supreme Court, Your Lordship.
Yes, this right on 114, 144, 114. What's the name? Miss Case's number?
164, ma'am.
164. Yes. See, Mr. Mata, we are all sympathies, but the court has to strike a balance. You understand it?
No,
very well.
no, that obviously I admit. Your Lordship is absolutely
it's an
right. But
application by the,
but the problem is now the
one of
HEMA
the
is...
6 applicant.
HEMA is
that
suffering, Your
applicant
Lordship.
brackets CM Sora to allow the collection of customary tolls from the trucks plying on the road Umdod to 0 point in the export of limestone. Stop. It is submitted by Mr. S. Mehta, Leonard Senior Counsel, that due to the order dated 10/5/2024 issued by the District Magistrate, all collections have since been stopped, and there are no orders operating that are allowing the same of Sora to collect the customary toll, which he maintains is a customary right. Stop. Next paragraph. Next paragraph. Mr. K. Paul, on behalf of the writ petitioner, opposite party, and Mr. Ndishulai, led AG, on behalf of the state respondents, have submitted that the situation as it pertains today is not conducive in as much as in earlier occasion on the orders of this court, when the respondent number 6 applicant herein had been permitted to collect the tolls, there was total mismanagement and defalcation of revenue. Stop. It's further submitted by the senior counsels that the issue in question before this court stems from the identity and nature of the road in question. Stop. As the situation is such, in consideration of the submissions of the parties, no orders are necessary at this stage. Only it is, but it is directed that the state respondents conduct a survey of the road within when? How long is the road?
Not very long. It's a very
1.78 kilometers.
Yes, conduct a survey of the road as to whether it's feasible for them to take over the same, so that train incumbents are not affected in the interim. This certification.
Offline.
Always.
Sorry, Mr. Manta, you've seen the conduct, what to do.
No, the due to the conduct now CM has to suffer. I'm very sorry for that.
Sorry, what to do. Court can't look here or there. We have to balance everything. Yes.
Hati?
Obliged.
Yes. Where's your colleague? This is whose case?
Sir, Sridhar Thapa was handling this matter.
For the petitioner.
Ready with the matter?
My lord, looking in, let's have this matter after vacation, my lord.
My lords, an accommodation. I'm seeking an accommodation on behalf of Mr. S. Thapa today, lordships.
After vacation.
We may have the matter after vacation, lordships.
I'm for MECL, my lord, corporation.
Was it a pension?
No, my lord, this is regarding the electricity connection. They've given money to the MECL. However, the property is under dispute and they already have a connection in the name of the private respondents, my lord.
Oh,
So
that's Mrs. Sen's case.
My lord, yes.
I request the parties matter of the vacation. Yes.
Obliged, lordships.